name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in this court. Your case is a criminal case, and criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of cases because they have a higher punishment range. And your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious because they have a lower punishment range. If you had a felony case, the range, you have felonies which are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. As I said earlier, we only handle misdemeanor cases in this court. Now, if you had a felony case, for example, if you had a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail, a fine up to $10,000. You had, if you convicted of a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, a fine up to $10,000. For a conviction on a second-degree felony, the range of punishment is 2 to 20 years in the state penitentiary, a fine up to $10,000. A conviction for a first-degree felony, minimum is 5 to 99 years to life in the state penitentiary, a fine up to $10,000. Or if you had a capital murder, if you convicted, the range of punishment is the range of punishment is life or death if you're convicted. Sir, with the black hood, sir, 1 minute. Okay, now if you're convicted of a misdemeanor case, your misdemeanor cases are divided into 3 categories. You have a Class A misdemeanor, Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanor is, if you're convicted, it's fine only. You only can get a fine. You can't get any jail time for a Class C misdemeanor. Your Class C misdemeanors are cases that are handled in the JP court, which is Justice of the Peace Court, or the city court, which is a municipal court. And as I said earlier, for example, Class C misdemeanor is like a speeding ticket. That's a Class C misdemeanor. Not having your seatbelt on, that's a Class C misdemeanor. So the cases that you have in city court or in JP court, those are Class C misdemeanors. You can only have fine only. They come to this court when a person filed an appeal from those courts in that case, and then it comes up to us. But when it comes up to this court, we still, the range of punishment is still the same. It doesn't change, which means you can't get any jail time for it. You only can get a fine for a Class C misdemeanor. Now, Class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days in the county court. I mean, in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you had a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is 1 year. A fine up to $4,000, or you could be given both such fine and confinement. Now, the case that you have in this court is obviously classified as a Class A or Class B misdemeanor, or it could be a Class C if you filed an appeal from a city court or a municipal court. Now, Mr. Sammy, you represent somebody on the arraignment docket? It was Reef.
From CDC. I just spoke to Mr. Ham.
I see a refile. They have Ryan Matuska. Oh, you represent him on the felony. Yeah, Matuska represents him on the misdemeanor.
Well, that was, the felony was dropped down to misdemeanor. But I'll go talk to Jimmy, get that squared away, sir.
Yeah, it was a refile. Yeah, Matuska's representing him on the misdemeanor. Okay, now, ladies and gentlemen, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. Now, regarding your right to have an attorney, there's some paperwork that we're going to hand out to you. The bailiff is going to hand out to you, and it will have the information on there regarding your rights to have an attorney. Now, you also have a right to have a trial by jury. You also have a right to have witnesses to come to court test, and you also have a right to have discovery. And what the court is going to do, I will go over those rights with you, let you know what your rights are, what your options are in your particular case. Now, our bailiff is going to hand out some paperwork to you. In that paperwork, it will discuss, first of all, the rights that you have as a defendant in a criminal case. Now, and it will be titled Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney if you desire to hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you may change your mind and may request counsel from the court. Now, on the document that's being handed out to you, at the bottom of that document is, I've just read all of that information at the top of the document. When I was speaking to you earlier, or just now, I was reading that information. At the bottom of this document, it states in bold letters, defendant's choice. Marking issues next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case by this court, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign the document that's titled defendant, and you will place today's date, September 27th, on the line that's dated date. That's September 27th of 2022. Now, for those of you who will be waiving your right to have an attorney and desiring to represent yourself, you would have to read and sign the second document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 27th date of September of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign on the line that's titled defendant, and you will date it today's date, September 27th of 2022. Now, as I mentioned earlier, you not only have a right to have an attorney, but you also have a right, you have other rights. One of the other rights that you have is a right to have a trial by jury. Now, where the young lady is sitting in this area over here, we call it the jury box. You'll have a right to have 6 citizens from Jefferson County to sit on your jury, who will sit in that area, and they will listen to all of the evidence in your case. After listening to all of the evidence, they will deliberate, and then they will decide whether or not to find you guilty or not guilty. Now, your case can also come before the court in 3 other ways. You can come before the court by way of what is called a bench trial. And what a bench trial is, it's a trial by judge only. In essence, you'll be waiving or giving up your right to have a trial by a jury, and your case will come before the court by a trial by judge only. And if your case comes before the court by way of a plea bargain agreement, that just simply means that you and the state have reached an agreement to settle your case. And once you and the state have reached an agreement to settle your case will come before the court or before the judge. And the judge will decide whether or not the judge will follow or not follow the plea bargaining agreement. In essence, to go along with the plea bargaining agreement or not go along with the plea bargaining agreement. If the judge does not go along with your plea bargaining agreement, you will have a right to withdraw your plea bargain, which means you have a right to take it back. Okay. And if, as I said earlier, if the judge doesn't go along with your plea bargaining agreement, you have a right to take your plea bargain back. Now, if you take your plea bargain back, then your case will go back to square one. It'll be as though you never entered a plea bargain agreement. All right. Now, the other thing is your case can come before the court by way of an unagreed plea bargain agreement. What that means is you and your attorney have not been able to reach an agreement with the state of Texas to settle your case. Therefore, you want your case to come before the judge and have the judge decide what the punishment will be in your case. All right. So just to recap, you have right to have a trial by jury. Now, if you waive your right to have a trial by jury, then your case can come before the court in one of three ways. It can come before the court by way of a bench trial, that's a trial by a judge only, or it can come before the judge by way of an agreed plea bargain agreement. You and the state have reached an agreement, or it can come before the court by the judge by way of an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court to testify in your case. They can testify for you or against you. And if you're representing yourself, you'll be able to ask them questions. If you're represented by an attorney, your attorney will be able to ask them questions while they're on the witness stand. We call that either direct examination or cross-examination. Now, you have a right to waive or give up your right to have witnesses to come to court. And if you waive or give up your right to have witnesses to come to court, that just simply means that you and your attorney will not be calling witnesses to testify in your case. It does not mean that the state of Texas or the district attorney will not be calling witnesses to testify. They will be calling witnesses. Now, you also have a right, we call it a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify against yourself in your case, and the state of Texas or the district attorney's office cannot force you to testify against yourself in your case. That's the Fifth Amendment right against self-incrimination. I know sometimes people watch television, they hear the term, people say, I take the fifth. Okay, that's what they mean. I'm not testifying, I'm not saying nothing, I take the fifth. And so you have a right, you have a Fifth Amendment right against self-incrimination not to testify against yourself. Now, you can waive or give up that right against self-incrimination. Now, if you waive or give up that right against self-incrimination, that just simply means that you will not that simply means that you will be testifying in your case. In essence, you're giving up the right not to testify, and so you will be testifying in your case. You also have a right to have discovery. And what discovery means is you have a right to see the evidence that the state has against you in your case. For example, you have a right to see the documents, you have a right to see witness statements, you have a right to see videos, you have a right to hear tapes, you have a right to see pictures, you have a right to see instruments, whatever evidence that they have against you in your case, you have a right to have access to that. We call that a right to have discovery. Now, you can waive your right to have discovery, which means that you have a right to give up your right to have discovery. And by doing so, if you give up your right to have discovery, then you will not be seeing the evidence, or you will not have access to the evidence because you're giving up that right to see the evidence in your case. Now, the other thing is, everybody here, you've been arrested, you've been to jail, you bonded out of jail. You either out of jail in one of three ways. You either out on a cash bond, which means that you paid the full amount to get out of jail, or you're out on what is called a surety bond, which means you have a bondsman that you paid a certain percentage of that bond to have them to get you out of jail, or you may be out on what is called a PR bond, which means personal recognizance bond. That means that you did not have to pay any money to get out. You've been released to your own personal recognizance, and you're responsible for being here yourself. Now, every day that you have spent in jail on your case, that can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail, and let's say the state of Texas or the district attorney's office is offering you 5 days in jail as your punishment. Then what that means is if you accept their offer, that means that you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you will be given credit for time that you have already served. Now, if the state is offering 7 days in jail and you have served and you've stayed 5 days in jail, that means you would have to only do 2 more days in jail on your case. Now, every day that you spent in jail also counts as $100 a day toward your fine and court costs. So if we use that same example, that is, you were in jail for 5 days. If the state is offering you a fine and court costs to settle your case for a $500 fine and court costs, then that simply means that you spent 5 days in jail, that's $500. You won't have to pay anything because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they offer you, say, $700 fine and court costs, that means you'd have to pay $200 because you've already served 5 days, that's $500. So you'll have $200 left. Now, you'll be required to pay it on the day that you enter your plea of your case. Now, if you cannot pay it on that date, then the court can allow you to pay it off in installments, which means the court can put you on a payment plan and you can pay it off so much per month until it's paid off. Now, if you cannot pay it off by way of installments or a payment plan, then the court can convert your fine and court costs to community service. And what that means is every hour that you perform in community service, you will receive $12.50 that will go toward your fine and court costs. So for example, if you work 8 hours of community service, and then that's $100. So if you work 8 hours one day, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program where the district attorney's office will dismiss your case and you can get it removed from your record. Okay, the way it works is as follows. First of all, you have to make an application. You have to get an attorney to help you make an application for the program. It cannot be an offense involving resisting arrest, unlawfully carrying a weapon, and it has to be your first offense. Now, and if you qualify, you get into the program, they'll dismiss the case. Once you complete the program, you can get it expunged. Expunged means erased, deleted, or wiped off from your criminal record. Okay. And if you're interested in that program, just let us know, and then we'll direct you to the proper person who can assist you at getting into the program with the district attorney's office. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has a program that is called Veterans Court. With the Veterans Court is for any veteran. And you get into the program, complete the program, they'll dismiss the case, you can get it expunged, which means wiped off or deleted or erased from your record. Now, if you're a veteran, if you're interested in that program, and I think that's the only criteria is you to be a veteran, just let us know and we can direct you to the district attorney's office. We have some prosecutors who's here, they're in the back, and they can talk to you about the veterans program. Now, this court, County Court at Law number 2, has a program that is called, we call it the CSI program, stands for Community Safety Initiative. It's a program that I started within the first 100 days of taking this job or being elected to this job. And, well, I say being elected, but once I took the bench within the first 100 days, we started a program called the CSI program, the Community Safety Initiative. It's a program designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the way the program works is we address the issue of what is called recidivism. Recidivism means how people continue to commit crimes one after another, over and over. That's recidivism. And so we address that through our Community Safety Initiative. Now, we have partnerships with local agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. We have some people, young people who are in the jury box. They're from the Spindletop Center. Deputy Hinton is going to come to you a little later and tell you give you a little bit more information about that program. But what the program entails is as follows. With the Spindletop Center, they'll be able to do what is called a private interview. And once and we have a jury room that they can conduct private interviews, and they'll be able to, the Spindletop can do an assessment. They can develop a treatment plan for you, either outpatient or inpatient. Now, in order to participate in that program, you don't have to be insane or incompetent. You can have any type of mental health issues. It could be anxiety, depression, bipolar, schizophrenia, psychosis, PTSD, or a whole host of other mental illnesses that an individual may have. They'll be able to address that. Now, if anybody have issues or problems with drugs or alcohol, Spindletop has a program that is called ATAR, and our local Alcohol and Drug Abuse Council has a program that is called OZOR. With those programs, they're able to do an interview or screening. They can do an assessment, and then they can develop a treatment plan either for outpatient or inpatient treatment as well. Now, if you are unemployed and do not have a job, or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of the areas that you select, they will assist you at getting a job in the area that you're trained in. Now, if you do not have your high school diploma, CICE has a program, well, they have a GED program, which means you can get your graduate equivalence exam, diploma. And all of these programs that I've just mentioned to you will not cost you anything but time. They are free. And the only thing you have to do is have a desire to be in the program. And once you're in the program, then you'll be able to use that program Not only that, but you could use the program for community service. All of these programs that I just mentioned could be used as community service. I mentioned to you that you can get community service hours that can go towards your fine costs and with your fine and court costs. So for example, let's say you cannot, you have a fine and court cost, but you can't pay the fine and court costs. We convert the fine and court costs to community service. And let's say you're in the program, say at Spindletop, or you're in the program CICE while you're job training, or you're working on the GED. Every hour that you're in any one of these programs, you'll have $12.50 that will go toward your fine and court costs, and $12.50 that will go toward your fine and court costs. And not only it will go toward your fine and court costs, but 1 hour will be also go toward your community service. So you're actually doing one thing. You're actually doing one thing, but you're getting credit for three things. You're getting credit for being in the program, you're getting community service hours, and you're getting $12.50 that will go in toward your fine and court costs. So you kill 3 birds with 1 stone. And as I said earlier, all of these programs are free, does not cost you anything. Only thing you have to have a desire is to be in the program. And as I stated earlier, these programs was programs that we started in March of 2017. And if you're interested in the programs, just let us know. And I tell people this all the time: when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in the community in which we live. In county court at law number 2, we do not just arrest the problem, we address the problem. And we believe that we don't just give time, we take our time, because we're trying to produce productive people. And we believe that if we produce productive people, we can address the issue of recidivism, because productive people will not commit crimes because they have too much to lose. So if you're interested in any one of these programs, just let us know and we'll be happy to assist you. Now, the paperwork that has been handed out to you, once Deputy Hinton finish talking to you, tell you something about their program, you can fill it out. If you need any assistance, you just let us know, and then we'll be happy to assist you, okay? At this time, I represent to you Deputy Hinton with Spindletop.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my partner, Sarah. Sarah is a qualified mental health professional with Spindletop. The reason we are here today in this courtroom is because the judge graciously invited us in here to take care about every single person that comes before us being. But the judge has found, or statistics prove, is those who appear with legal issues commonly have mental health, substance use disorders, or just a lack of community resources to help you in your particular situation. Now, this may be your first time to be here, it may be your 10th time to be here. There's still hope. In fact, Sarah has a template in place where they can actually plug you into community resources that will help you, again, with your particular situation. We don't know what that is, so I'm going to ask you to do something that may be a little bit uncomfortable for you, but I'm going to ask you at some point in time, either today in court or when we talk to you by phone, share that need with us so we can get that information to you. Now, I have a flyer here I want to give to everyone before you leave. On the back, it tells you a little bit about why we're here in the court and some of the benefits associated with it. But on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. You also have this demographic form, which gives us information about who you are and also helps us better serve you and have the information to research already, the information that you will need to help you in your particular situation. We'll collect those in a little bit. But if you don't remember anything else, I want you to remember this. We care about you. We are here to help you. That's our goal. That's our objective. If you allow us to do that, we will help you. When the court goes to recess here just shortly, I'm going to visit with you. If you have any questions or anything regarding this form, we'll also be getting this to you as well. And we'll visit with you in private. All your information is private. No one else will know about anything about your situation because it's all HIPAA regulated. Thank you very much. Thank you, Your Honor.
Okay. Now, ladies and gentlemen, I had mentioned to you earlier that you have that paperwork that you have. We're going to give you an opportunity to go through that paperwork, sign your name, put your initials on appropriate lines. If you need any help, we have personnel with our court who will be happy to assist you with filling out that paperwork. So at this time, the court is going to be in recess to give you an opportunity to take care of the paperwork. And